Our objective today is to understand how medicine and law intersect in addressing the complex issue of substance use disorders. Addiction and dependence are not just medical or legal problems. They sit at the crossroad of public health, ethics, and criminal justice. We'll explore how Republic Act number 9165, the Comprehensive Dangerous Drugs Act of 2002, deals with these conditions and how both prosecution and defense may use medical evidence to support their positions. Ultimately, our goal is to gain insight into how justice and compassion can coexist in handling drug-related cases. So this presentation will be divided into 5 major parts. First, we will clarify the conceptual and medical difference between dependence and addiction. Second, we'll examine the physiological processes that lead to these conditions. Third, we'll review the key legal provisions under RA 9165 that address drug use and rehabilitation. Fourth, we'll discuss how the law prosecutes and defends drug-related cases, focusing on the use of medical evidence. Finally, we'll touch on the role of medico-legal experts, doctors, psychiatrists, and forensic scientists who provide the bridge between medical findings and judicial decisions. Dependence is a physical adaptation where stopping the substance abruptly causes withdrawal, whereas addiction is a chronic behavioral disorder with compulsive use despite harm. Every addict is dependent, but not every dependent person is addicted. This distinction guides expert testimony and influences how courts assess criminal liability and sentencing. Dependence arises because the brain adapts to regular substance exposure to maintain homeostasis. Tolerance develops, requiring increased doses for the same effect, and abrupt cessation triggers withdrawal. In court, these physiological facts explain why a dependent individual may be compelled to continue use, framing the medical context of behavior. For the physiology of addiction, it's different. The neural pathways are different from those of dependence. So, there is a brain reward circuits in addiction. Here, the ventral tegmental area initiates the reward signal by releasing dopamine in response to pleasurable stimuli or drugs. The nucleus accumbens interprets dopamine, generating pleasure and reinforcing behavior. Drugs hijack this system, making the substance feel essential. The prefrontal cortex, which is responsible for judgment and self-control, weakens in addiction, leading to risky decisions despite awareness of harm. The pleasure-reward pathway functions as a motivational engine. Addictive drugs overstimulate it, causing repeated drug-seeking behavior. Dopamine overload not only drives pleasure but also fuels curiosity and novelty seeking. Excessive levels distort motivation and can perpetuate addiction. Methamphetamine exemplifies this. Massive dopamine release rewires reward circuits, reinforcing use as if it were critical for survival. Understanding this neural mechanism is key for rehabilitation planning and legal assessments, as they explain impaired control and compulsive behavior. RA 9165 criminalizes drug possession, use, and trafficking, but provides for rehabilitation for dependent persons. Sections 11 and 15 define possession and use. Section 36 mandates drug testing, and Section 54 offers voluntary rehabilitation. The law acknowledges that addiction is a medical condition that may require treatment instead of imprisonment. Under law, specifically Section 54, a drug-dependent person is legally recognized. The law acknowledges that these physiological changes can affect a person's ability to exercise full control or sound decision-making. Because of this, RA 9165 provides that such individuals may be rehabilitated rather than punished, provided they voluntarily submit themselves for treatment. This means the justice system sees dependence not merely as a criminal matter, but also as a medical and psychological condition that needs healing. In essence, the law integrates medical understanding into legal compassion. It recognizes that the brain's adaptation to drugs alters willpower and behavior, and that for dependence, treatment is often more just and effective than punishment. When dependence deepens, it can evolve into what we call addiction, a compulsive behavior where drug seeking and drug taking dominate the person's thoughts and actions. Unlike mere dependence, which is primarily physiological, addiction involves a loss of behavioral control. This is where a person continues using drugs despite knowing the harm it causes to health, relationships, work, and even legality. Neuroscientifically, addiction engages the reward circuitry of the brain, especially the Mesolimbic dopamine system, involving, as I have said, the ventral tegmental area, the nucleus accumbens, and prefrontal cortex. These areas control pleasure, motivation, and impulse regulation. When repeatedly exposed to addictive substances, these circuits becomes rewired. Dopamine, the neurotransmitter of reward, floods these pathways, giving intense euphoria. Over time, natural dopamine production drops, and the person needs the drug just to feel normal. The prefrontal cortex, which governs decision making and self control, becomes less active. This leads to compulsive, often irrational behaviors, including criminal acts such as possession, sale, or trafficking of drugs. Under RA 9165, when a person's dependence progresses into addiction and drives illegal behavior, such as possession under Section 11 and use under Section 15, or trafficking under Section 5, criminal liability attaches. So this slide summarizes how medical physiology intersects with legal interpretation under RA 9165. Understanding this connection helps us distinguish who should be treated and who must be prosecuted. Let's go through each aspect. Dependence. Physiologically, dependence happens when the brain adapts to the constant presence of a drug. The body reaches a new set point. It functions normally only when the drug is available. When the substance is removed, the nervous system becomes unstable, producing withdrawal symptoms like tremors, anxiety, or sleeplessness. This adaptation involves regions such as the locus ceruleus, the nucleus solitarius, and hypothalamus, which regulate stress, breathing, and autonomic functions. Neurotransmitters like dopamine, GABA, and norepinephrine are key players in maintaining this altered balance. Legally, RA 9165 recognizes dependence as a medical condition. Under sections 54 and 55, a person found to be drug dependent may voluntarily submit to treatment and rehabilitation instead of being punished. The law therefore integrates a medical understanding into the justice system, acknowledging that physiological adaptation can affect control, intent, and decision making. For addiction, when dependence deepens, it can progress into addiction. So it's, as I have said, a compulsive state where drug-seeking behavior overrides rational decision making. The key physiological change here lies in the brain's reward circuitry, particularly the mesolimbic dopamine system, involving the ventral tegmental area, the nucleus accumbens, and prefrontal cortex. These areas control pleasure, motivation, and self-control. In addiction, the dopamine reward signals overpower the brain's control circuits, making the behavior compulsive even when the person knows it's harmful or illegal. So under 9165, this has major legal consequences. So addiction often leads to illegal possession, use, trafficking of dangerous drugs, offenses which are penalized under sections 5, 11, and 15. However, courts are also instructed to evaluate the mental state or the mens rea of the accused. If addiction demonstrably impairs voluntary control, the court may refer the individual for rehab or treatment instead of direct imprisonment, especially if the person voluntarily surrenders or is diagnosed as clinically dependent. For withdrawal, physiologically, withdrawal is the body's reaction when the drug supply stops. The locus ceruleus, a brainstem center that releases norepinephrine, becomes hyperactive. This surge in norepinephrine explains symptoms like sweating, elevated heart rate, tremors, and agitation. So withdrawal proves that the body has physiologically adapted to the substance, an important medico-legal finding. In court, evidence of withdrawal symptoms or a medical diagnosis of withdrawal can support a defense for rehabilitation rather than prosecution. It demonstrates that the person's behavior stems from a neurochemical imbalance rather than pure criminal intent. In other words, withdrawal underscores the medical basis for treatment under Section 54. For relapse, lastly, relapse is part of the chronic nature of addiction. Even after detoxification, hypothalamic and cortical circuits retain craving memories, associations between certain cues and drug use. Neurotransmitters like glutamate and dopamine reactivate these memories under stress or exposure to triggers, prompting the urge to use again. Legally and medically, relapse is not a failure but a signal that continuous care is needed. The law supports this view. Under 9165, rehabilitated persons must undergo aftercare programs to monitor recovery and prevent reoffending. Courts and treatment centers therefore consider relapse as part of a medical continuum, not an immediate cause for reincarceration, unless accompanied by new criminal acts. Medical findings often guide legal outcomes. A dependent individual may enter rehabilitation while traffickers face prosecution. Accurate medical diagnosis confirming dependence or addiction informs legal classification and ensures that both medical reality and public safety are considered in sentencing. The criminal prosecution process. Drug cases follow a structured legal process. Arrests are followed by lab confirmation and strict adherence to the chain of custody. Expert witnesses provide testimony linking physiological effects to legal criteria. Proper handling of evidence and expert interpretation are critical in establishing liability. Medico-legal experts serve as the bridge between medical science and legal interpretation. Psychiatrists determine the mental state of the accused. Toxicologists validate laboratory results. Their role goes beyond diagnosis. They interpret findings within the legal framework, helping courts distinguish between a dependent user and a criminal trafficker. The credibility and clarity of their testimony can profoundly influence sentencing and access to rehabilitation. The defense may assert that the accused lacked knowledge or intent, or that they voluntarily sought treatment under Section 54. The law encourages dependents to rehabilitate by suspending criminal penalties upon successful completion of treatment. Medical certificates and psychiatric evaluations become crucial evidence here, supporting claims that the accused actions were driven by dependence rather than deliberate criminality. These defenses promote a rehabilitative, not punitive, approach to justice. For the prosecution, proving guilt means demonstrating possession or use beyond reasonable doubt, supported by an intact chain of custody of the substance. Expert witnesses may testify to behavioral patterns that suggest intentional use rather than medical dependence. Prosecutors often challenge defense claims of rehabilitation by questioning the authenticity of medical findings or compliance with 1965's procedural safeguards. Let's clarify what the law means by a screening test. Under Section 36 of 9165, it provides that authorized drug testing must employ two testing methods. First, a screening test, and second, a confirmatory test. Under the law's definition, in paragraph H, a screening test is a rapid test performed to establish a potential or presumptive positive result. This is the initial test done on a urine or biological sample to check for the possible presence of a controlled substance. In practical terms, this is like the first filter. It uses immunoassay-based technology which can quickly indicate whether the sample might contain substances such as methamphetamine or marijuana. However, it does not conclusively prove that the person has used drugs. It only signals that further testing is needed. That's why Section 36 requires a second step, the confirmatory test, which validates or disproves the initial result using more sophisticated laboratory techniques such as gas chromatography, mass spectrometry. The distinction is crucial in legal proceedings. If only a screening test is performed and no confirmatory test follows, the result is merely presumptive and cannot be the basis for conviction under Section 15 for drug use. So in essence, the screening test is the preliminary rapid check designed to detect potential drug use, while the confirmatory test provides the scientifically validated evidence needed for legal accountability. So let's clarify what the law means by screening test under Section 36. It provides that authorized drug testing must employ um, so we have finished this. Now we go to the random drug test. Under Section 36C, certain populations are mandated to undergo random drug testing. For instance, students of secondary and tertiary schools shall be randomly tested to detect potential use of dangerous drugs. Officers and employees of public and private offices are likewise subjected to random testing to ensure a drug-free workplace. So these provisions are implemented through specific guidelines issued by the relevant agencies. For example, the Department of Education has a set of general guidelines on random drug testing of high school students, which operationalizes Section 36C for educational institutions. In practice, random drug testing involves selecting individuals at unspecified times and without prior notice. This unpredictability serves as a deterrent against the use of dangerous drugs while also enabling early identification of persons who may benefit from rehabilitation or counseling rather than immediate prosecution. It is important to note that random testing does not automatically lead to criminal liability under Section 15. Positive results from random tests are typically handled administratively or through rehabilitation programs unless accompanied by other legally sufficient elements for prosecution, such as apprehension for an Article 2 offense. In essence, random drug testing is a preventive and rehabilitative measure mandated by law aimed at early detection, deterrence, and public safety rather than punitive action alone. So these are the conditions when statutory rehabilitation is proper. For voluntary submission for treatment, the condition is that the drug-dependent person voluntarily applies for treatment before being charged or while the case is pending. So the requirements are the person admits drug dependence and applies for rehab. Application is verified by a DOH accredited physician or Drug Dependency Examination Center. The court or the DDB approves the rehab plan after proper assessment. The effect for voluntary submission for treatment, if successful rehabilitation and after judicial discharge, the person is exempt from criminal liability for drug use or possession for personal use. A second offense, however, disqualifies the person from this exemption. So it is proper when the offender shows genuine dependence rather than trafficking intent. The person applies before conviction and demonstrates good faith and willingness to reform. How about for compulsory submission for treatment? The condition is that the court finds the accused to be a drug dependent after conviction or during proceedings for violation of Section 15 or use of dangerous drugs. So the requirements are as follows. The court orders drug dependency examination by a DOH accredited physician. If confirmed, the accused is committed to rehab, and rehabilitation lasts for not less than 6 months, followed by aftercare and follow-up for up to 18 months under DOH supervision. The effect under compulsory submission for treatment is if rehabilitation is completed successfully, the person may be released under court supervision and exempted from further criminal prosecution. It's proper when the court determines medical dependence, not mere use or trafficking. The accused is not involved in sale or distribution, and public safety allows supervised release. Suspension of sentence for first-time offenders under Section 66. The condition here is that a first-time offender convicted under Section 15 may have their sentences suspended to allow rehab. The requirements are as follows. The offender has no prior conviction under RA 9165. The court, after confirming drug dependence, refers the offender for rehabilitation under DOH supervision. And lastly, the offender must comply with all conditions, that is, for treatment, reporting, and community integration. The effect here is, upon completion, the case may be dismissed and records expunged under Section 70. It's proper when the offender is a first-time drug user, not a dealer or trafficker. The goal is restorative justice, rehabilitation over incarceration. Presidential clemency or parole on medical grounds. The condition here is a convicted person may be granted clemency or parole if certified by the DOH as genuinely rehabilitated. And it's proper when the offender has served part of the sentence and is clinically proven rehabilitated. What are the medico-legal implications on the statutory rehabilitation under 9165? These are as follows. Dependence must be medically proven by a DOH accredited physician or rehab center. Addiction without trafficking intent favors rehabilitation. Medical reports, toxicology results, and psychiatric evaluations form key evidence for the court's determination. So the prosecution or defense may invoke sections 54 or 61 depending on the timing and nature of the case. So these are the summary on the statutory rehab that we have talked about. Recent jurisprudence include People versus Hementiza, Suliano, Relato, Lopez, Tamayo, and Arnaldo Lo. In summary, when dealing with Section 15 on drug use cases, it is crucial to follow procedural and evidentiary safeguards. Charge screening. The first principle is that a Section 15 charge should never be filed solely based on random or administrative drug tests. These results are intended for preventive or rehab purposes, not immediate criminal prosecution. Instead, administrative remedies or referral to a rehab program should be pursued. Criminal charges under Section 15 are appropriate only after lawful apprehension or arrest, specifically in connection with an Article 2 offense such as possession or trafficking, where the suspect's use of drugs can be legally attributed. The evidence checklist. To sustain a Section 15 prosecution, the state must ensure that all elements are properly documented. Proof of apprehension or arrest tied to an Article 2 violation. Screening test result indicating presumptive positivity. Confirmatory test report verifying the presence and type of the controlled substance. Chain of custody documentation for the urine specimens strictly following laboratory protocols. Proof of first versus subsequent offenses which affects rehab versus sentencing. Ensuring this checklist is complete prevents procedural dismissals and protects due process. How about plea bargaining? If proposing a plea to Section 15, it is important to anticipate prosecutorial concerns. For instance, evidence such as a negative drug dependency test or absence of recidivism can support a reduced charge of rehabilitation-oriented disposition. The Supreme Court precedent in Law v. People clarifies that policy-only objections by the prosecution, for example, based solely on internal DOJ preferences, may be overruled if the plea conforms to the legal framework and evidentiary standards. Judges may also impose conditions of compliance, such as participation in rehabilitation or periodic drug testing before accepting a plea. So in summary, careful screening, meticulous documentation, and strategic plea negotiation are key to handling Section 15 cases lawfully and ethically, ensuring that justice balances accountability with rehabilitation. Beyond legal definition lies an ethical dimension. Viewing addiction as a disease transforms how we design policies and deliver justice. Mandatory rehabilitation may work for some, but voluntary treatment grounded in personal accountability and medical guidance produces more lasting recovery. The legal system must therefore strike a balance, protecting society while upholding human dignity. Experts must advocate for evidence-based, humane approaches consistent with ethical and constitutional standards. So, in closing, justice must consider both the act and the mind behind it.